part of fundamental rights and fundamental duties. Abolition of titles, Article 18. Title is something that hangs to one's name as an appendage. During the British rule, there was a complaint from the nationalists that the power to confer titles was being abused by the government for imperialistic purposes and for corrupting public life. The Constitution seeks to prevent such abuse by prohibiting the state from conferring any title at all. It is to be noted that the ban operates only against the state. It does not prevent other public institutions such as universities to confer titles or honors by way of honoring their leaders for men of merit. The state is not debarred from awarding military or academic distinctions, even though they may be used as titles. The state is not prevented from conferring any distinction or award, say for social service, which cannot be used as a title, that is, as an appendage to one's name. Thus, the award of Bharat Ratna or Padma Vibhushan cannot be used by the recipient as a title and does not accordingly come within the constitutional provision. In 1954, Government of India introduced decorations in the form of medals for 4 categories, namely Bharat Ratna, Padma Vibhushan, Padma Bhushan and Padma Shri. While the Bharat Ratna was to be awarded for exceptional services towards the advancement of art, literature and science, and in recognition of public service of the higher order. The others would be awarded for distinguished public service in any field, including service rendered by government servants in order of the degree of the merit of their service. Though the foregoing awards were made decorations and not intended to be used as appendage to the names of the person to whom they are awarded, there was a vehement criticism from some quarters that the introduction of these awards violated Article 18. The critics pointed out that even though they may not be used as titles, the decorations tend to make distinctions according to rank, contrary to the preamble, which promises equality of status. The critics gained strength on this point from the fact that the decorations are divided into several classes, superior and inferior, and that holders of the Bharat Ratna have been assigned a place in the warrant of procedure, 9th place, that is just below the cabinet ministers of the Union, which is usually meant for indicating the rank of the different dignitaries and high officials of the state. In the interest of discipline in the administration, the result was the creation of a rank of persons on the basis of government recognition in the same way as the conferment of nobility would have done. Another criticism which seems to be legitimate is that there is no sanction either in the Constitution or in any existing law against a recipient of any such decoration appending it to his name and thus using it as a title. Any such use is obviously inconsistent with the prohibition contained in Article 18(1), but it is not made an offense either by the Constitution or by any law. The apprehensions of the critics on this point were unfortunately justified by the fact that in describing the author on the title of an issue of the Hamelin lectures, the decoration Padma Vibhushan was in fact appended as a title. The protest raised by Acharya Kripalani against the award of such decorations, which went unheeded earlier, was honored by the Janta regime 1977 by putting a stop to the practice of awarding Bharat Ratna etc. by the government. But it was restored by Mrs. Gandhi after her comeback. In this context, it is to to be noted that Article 18(1) itself makes an exception in favor of granting by the state of any military or academic distinction. The matter was taken to court, and the Supreme Court has now held that non-military awards by way of recognition of merit of extraordinary work, as for example the Padma Awards, are not titles of nobility and hence do not violate Article 14 or 18, provided they are not used as titles or prefixes or suffixes to the names of the awardee. Apart from the rights flowing from the above prohibition, certain positive rights are conferred by the Constitution in order to promote the ideal of liberty held out by the preamble. The foremost amongst these are the 6 fundamental rights in the nature of freedom, which are guaranteed to the citizens by the Constitution of India, Article 19. These were popularly known as the 7 freedoms. Under our Constitution, it has already been pointed out that in the original Constitution there were 7 freedoms in Article 19(1), but that one of them, namely the right to acquire, hold or dispose of properties, has been omitted by the Constitution 44th Amendment Act 1978, leaving only 6 freedoms in this article. They are freedom of speech and expression, freedom of assembly, freedom of association, freedom of movement, freedom of residence and settlement, freedom of profession, occupation, trade and business. Article 19 forms the core of our chapter on fundamental rights. It is essential for the readers to be familiar with the text of this article as it stands amended. All citizens have the right to freedom of speech and expression, to assemble peaceably and without arms, to form associations or unions, to move freely throughout the territory of India, to reside and settle in any part of India, and to practice any profession or to carry on any occupation, trade or business. Nothing in subclause A of clause 1 affect the operation of any existing law or prevent the state from making any law insofar as such law imposes reasonable restrictions on the exercise of right conferred by the said subclause in the interests of the sovereignty and integrity of India, the security of the state, friendly relations with foreign states, poor order, public order, decency or morality, or in relation contempt of court, defamation or incitement to an offense. Nothing in subclause B of the said clause shall affect the operation of any existing law insofar as it imposes or prevent the state from making any law imposing in the interests of the sovereignty and integrity of India or public order. Reasonable restrictions on the exercise of the right conferred by the said subclause. Nothing in the subclause C of the said clause shall affect the operation of any existing law insofar as it imposes or prevent the state from making any law imposing in the interest of the sovereignty and integrity of India or public order or morality. Reasonable restrictions on the exercise of the right conferred by the said subclause. Nothing in the subclause D, E of the said clause shall affect the operation of any existing law insofar as it imposes or prevent the state from making any law imposing reasonable restrictions on the exercise of any of the rights conferred by the said subclause, either in the interest of the general public or for the protection of the interest of any scheduled tribes. Nothing in subclause G of the said clause shall affect the operation of any existing law insofar as it imposes or prevent the state from making any law imposing in the interest of the general public reasonable restrictions on the exercise of the right conferred by the said subclause, and in particular nothing in the said subclause shall affect the operation of any existing law insofar as it relates to or prevent the state from making any law relating to The professional and technical qualification necessary for practicing any profession or carrying on any occupation, trade or business, or the carrying on by the state or by the corporation owned or controlled by the state of any trade, business, industry or service, whether to the exclusion complete or partial of citizen or otherwise any modern state. The guarantee of each of the above rights is therefore limited by our Constitution itself by conferring upon the state a power to impose by its laws reasonable restrictions as may be necessary in the larger interests of the community. This is what is meant by saying that the Indian Constitution attempts to strike a balance between individual liberty and social control. Since the goal of our constitutional system is to establish a welfare state, the makers of the Constitution did not rest with the enumeration of uncontrolled individual rights in accordance with the philosophy of laissez-faire, but sought to ensure that where collective interests were concerned, individual liberty must yield to the common goods, but instead of leaving it to the courts to determine the grounds and exempt of permissible state regulation of individual rights as the American Constitution does. The makers of our Constitution specified the preamble limitations in clause 2 to 6 of Article 19 itself. The state in this context includes not only the legislative authorities of the union and the states but also other local or statutory authorities, as for example municipalities, local boards, etc., within the territory of India or under the control of the government of India. So all of these authorities may impose restrictions upon the above freedoms, provided such restrictions are reasonable and are relatable to any of the goods of public interest as specified in clause 2 to 6 of Article 19. Thus the Constitution guarantees freedom of speech and expression, but this freedom is subject to reasonable restrictions imposed by the state relating to defamation, contempt of court, decency or morality, security of the state, friendly relations with foreign state, incitement to an offense, public order, maintenance of sovereignty and integrity of India. Decency or morality is not confined to sexual morality alone. It indicates that the action must be in conformity with the current standards of behavior or propriety. Hence, seeking votes at an election on the ground of the candidate's religion in a secular state is against the norms of decency and propriety of the society. It is evident that the freedom of speech and expression cannot confer upon an individual a license to commit illegal or immoral acts or to incite others to overthrow the established government by force or unlawful means. No one can exercise his rights of speech in such a manner as to violate another man's such right. Similarly, the freedom of assembly is subject to disqualification that the assembly must be peaceable and without arms and subject to such reasonable restrictions as may be imposed by the state in the interests of the public order. In other words, the right of meeting or assembly shall not be liable to be abused so as to create public disorder or a breach of the peace or to prejudice and sovereignty or integrity of India. Again, all citizens have the right to form associations or unions, but subject to reasonable restrictions imposed by the state in the interests of public order or morality individuality or the sovereignty or integrity of India. Thus, this freedom will not entitle any group of individuals to enter into a criminal conspiracy or to form any association dangerous to the public peace or to make illegal strikes or to commit a public disorder or to undermine the sovereignty or integrity of India. Similarly, though every citizen shall have the right to move freely throughout the territory of India or to reside and settle in any part of the country, this right shall be subject to restrictions imposed by the state in the interests of the general public or for the protection of any scheduled tribes. Again, every citizen has the right to practice any profession or to carry on any occupation, trade or business, but subject to reasonable restrictions imposed by the state in the interests of the general public and subject to any law laying down qualifications for carrying on any profession or technical occupation or enabling the state itself to carry on any trade or business to the exclusion of the citizens. Scope for judicial review. As pointed out earlier, one of the striking features of the provisions relating to fundamental rights in our Constitution is that the very declaration of the major fundamental rights is attended with certain limitations specified by the Constitution itself. In the United States, the Bill of Rights itself does not contain any such limitation to the rights of the individual guaranteed thereby, but in the enforcement of those rights, the court had to invent doctrines like that of police power of the state to impose limitations on the rights of the individual in the interests of the community at large. But as explained above in Article 19 of our Constitution, there is distinct clause attached to each of the rights declared containing the limitations or restrictions which may be imposed by the state or the exercise of each of the rights so guaranteed. For example, while the freedom of speech and expression is guaranteed, an individual cannot use this freedom to defame another, which constitutes an offense under the law. A law which may be made by the state under any of the specified grounds, such as public order, defamation, contempt of court, cannot be challenged as unconstitutional or inconsistent with the guarantee of freedom of expression, except where the restrictions imposed by the law can be held to be unreasonable by a court of law. That is how the competing interests of individual liberty and of public welfare have been sought to be reconciled by the framers of our Constitution, as Justice Mukherjee explained in the leading case of Gopalan versus State of Madras. There cannot be any such thing as absolute or uncontrolled liberty wholly freed from restraint, for that would lead to anarchy and disorder. The possession and enjoyment of all rights are subject to such reasonable conditions as may be deemed to be to the governing authority of the country to be essential to the safety, health, peace, general order and morals of community. The question therefore arises in each case of adjusting the conflicting interests of the individual and of the society. Ordinarily, every man has the liberty to order his life as he pleases, to say what he will, to go where he will, to follow any trade, occupation or calling at his pleasure, and to do any other thing which he can lawfully do without let or hindrance by any other person. On the other hand, for every protection of these liberties, the society must arm itself with certain powers. What the Constitution therefore attempts to do in dealing the rights of the people is to strike a balance between individual liberty and social security. Article 19 of the Constitution gives the list of individual liberties and prescribes in the various clauses the restraints that may be placed upon them by law so that they may not conflict with public welfare or general morality. It is by way of interpretation of word reasonable that the court comes into the field, and in each case when an individual complains to the court that his fundamental rights has been infringed by the operation of a law or an executive order issued under a law, the court has get to determine whether the restriction imposed by the law is reasonable, and if it is held to be unreasonable in the opinion of the court, the court will declare the law and the order, if any, to be unconstitutional and void. Tests of reasonableness of a restriction. The expression reasonable restriction seeks to strike a balance between the freedom guaranteed by any of the sub-clauses of Article 19(1) and the social control permitted by any of the exceptions in Clause 2 to 6. It is to be seen, therefore, what criteria or tests has been laid down by the Supreme Court for determining whether the restriction is reasonable or not. The Supreme Court has said that a restriction is reasonable only when there is a proper balance between the rights of the individual and those of the society. The test of reasonableness should therefore be applied to each individual statute impugned, and not abstract or general pattern of reasonableness can be laid down as applicable to all cases. The nature of the right alleged to have been infringed, the underlying purpose of the restriction imposed, the extent and urgency of evil sought to be remedied thereby, the disproportion of the imposition, the prevailing conditions at the time should all enter into the judicial verdict. Thus, the formula of subjective satisfaction of the government and its officers with an advisory board to review the materials on which the government seeks to override a basic freedom guaranteed to the citizen may be viewed as reasonable only in very exceptional circumstances, as for example in providing internment or externment for the security of the state and within the narrowest limits, and not to curtail a right such as the freedom of association in the absence of any emergent or extraordinary circumstances. All the attendant circumstances must be taken into consideration, and one cannot dissociate the actual contents of the restrictions from the manner of their imposition or the mode of putting them into practice. The Supreme Court has held that in examining the reasonableness of a statutory provision, whether it is violated the fundamental rights guaranteed under Article 19, one has to keep in mind the directive principles of the state policy. The restrictions must not be arbitrary or an excessive nature, going beyond the requirements of the interest of general public. No abstract or general pattern or a mixed principle to judge the reasonableness of the restrictions can be laid down so as to be of universal application, and the same will vary from case to case, as also with regard to the changing conditions, values of human life, social philosophy of the Constitution, prevailing conditions, and surrounding circumstances. A just balance has to be struck between the restrictions imposed and social control envisaged by Article 19(6). Prevailing social values as also social needs which are intended to be satisfied by the restrictions, there must be a direct and proximate nexus or reasonable connection between the restrictions imposed and the other and the object sought to be achieved by the act. That being so, a strong presumption in favor of the constitutionality of the act will naturally arise. It follows, therefore, that the question of reasonableness should be determined from both the substantive and procedural standpoints. Hence, in order to reasonable, the restriction imposed must have a reasonable relation to the collective object which the legislation seeks to achieve, and must not go in excess of that object. Or, in other words, the restriction must not be greater than the mischief to be prevented. Legislation which arbitrarily or excessively invades the right cannot be said to contain the quality of reasonableness. Thus, the object of an act was to provide measure for the supply of adequate labor for agriculture process in beedi manufacturing areas, but the order of the Deputy Commissioner made thereunder forbid all persons residing in certain villages from engaging in the manufacture of beedis during the agricultural season. The Supreme Court invalidated the order on the ground that it imposed an unreasonable restriction upon the freedom of business, Article 19(1)(g) of those engaged in the manufacture of beedis, because the object of the act could be achieved by legislation restraining the employment of agricultural labor in the manufacture of beedis during the agricultural season, or by regulating hours of work on the business of making beedis. A total prohibition of the manufacture imposes an unreasonable and excessive restriction on the lawful occupation of the manufacturing beedis. While the foregoing aspect may be said to be the substantive aspect of reasonableness, there is another aspect, which the procedural aspect, relating to the manner in which the restrictions have been imposed. That is to say, in order to be reasonable, not only the restriction must not be excessive, the procedure or manner of imposition of the restriction must also be fair and just. In order to determine whether the restrictions imposed by law are procedurally reasonable, the court must take into consideration all the attendant circumstances, such as the manner of its imposition, the mode of putting it into practice. Broadly speaking, a restriction is unreasonable if it is imposed in a manner which violates the principle of natural justice. For example, if it seeks to curtail the right of association or the freedom of business of a citizen without giving him an opportunity to be heard, it has also been laid down that in the absence of extraordinary circumstances, it would be unreasonable to make the exercise of a fundamental right depend upon the subjective satisfaction of the executive. There is no specific provision in our Constitution guaranteeing the freedom of the press, because freedom of the press is included in the wider freedom of expression, which is guaranteed by Article 19(1)(a). Freedom of expression means the freedom to express not only one's own views but also the views of others, and by any means, including printing. But since the freedom of expression is not an absolute freedom and is subject to the limitations contained in Clause 2 of Article 19, laws may be passed by the state imposing reasonable restrictions on the freedom of the press in the interests of the security of the state, the sovereignty and integrity of India, friendly relations with foreign states, public order, decency or morality, or for the prevention of contempt of court, defamation or incitement to an offense. Absolute, unlimited and unfettered freedom of press at all times and in all the circumstances would lead to disorder and anarchy. The press as such has no special privileges in India from the fact that the measure of freedom of the press is the same as that of an ordinary citizen. Under Article 19(1)(a), several propositions emerge. The press is not immune from the ordinary forms of taxation, the application of the general laws relating to industrial relations, the regulation of the condition of service of the employees, but in view of the guarantee of freedom of expression, it would not be legitimate for the state to subject the press to laws which take away or abridge the freedom of expression or which would curtail circulation, and thereby narrow the scope of dissemination of information or fetter its freedom to choose its means of exercising the right, or would undermine its independence by driving it to seek government aid. To single out the press for laying upon it excessive and prohibitive burdens which would restrict the circulation, impose or penalty on its right to choose the instruments for its exercise, or to seek an alternative media. To impose a specific tax upon the press deliberately calculated to limit the circulation of information when the constitutionality of an enactment especially directed against the press is challenged, the court has to test it by the standard of substantive and procedural reasonableness. As explained earlier, an enactment of this nature, the Punjab Special Powers Press Act 1956, came up before the Supreme Court in Birendra versus State of Punjab, and the court annulled one of its provisions while upholding another on the following grounds: a law which empowers the government to prohibit for any temporary period the entry of literature of a published specified class likely to cause communal disharmony would not be held to be reasonable if it complies with the procedural requirements of natural justice, but it would be unreasonable if it empowered the state government to prohibit the bringing into the state of any newspaper on its being satisfied that such action was necessary for the maintenance of communal harmony or public order, inasmuch as it placed the whole matter at the subjective satisfaction of the state government without even providing for the right of representation to the party affected. Since the expiry of the Press Objectionable Matter Act 1951 in 1956, there was no All India Act for the control of the press in India, but in 1976 Parliament enacted the Prevention of Publication and Objectionable Matter Act 1976 with more rigorous provisions and in a permanent form. In April 1977, the Janata government repealed this act. Subsequently, however, this position was further buttressed by inserting a new article in the Constitution itself, Article 361A, by the Constitution 44th Amendment Act 1978. Censorship of the press again is not especially prohibited by any provision of the Constitution like other restrictions. Therefore, its constitutionality has to be judged by the test of reasonableness within the meaning of Clause 2. Soon after the commencement of the Constitution and prior to the insertion of the word reasonable in Clause 2, the question of validity of censorship came up before our Supreme Court in the case of Brij Bhushan versus State of Delhi. The fact of this case were as follows: Section 7(1)(c) of the East Punjab Safety Act 1949 provided that the provincial government, if satisfied that such action is necessary for preventing or combating any activity prejudicial to the public safety or the maintenance of public order, may, by order in writing, addressed to a printer, publisher, editor require that any matter relating to a particular subject or class is subject shall before publication be submitted for scrutiny. Similar provisions of the Madras Maintenance of Public Order Act 1949 were challenged in the allied case of Ramesh Thapar versus State of Madras. The majority of the Supreme Court had no difficulty in holding that the imposition of pre-censorship on a journal was an obvious restriction upon the freedom of speech and expression guaranteed by Clause 1A of the Article 19, that public safety or public order was not covered by the expression security of the state, and impugned law was not therefore saved by Clause 2 as it then stood. After these decisions, Clause 2 was amended by the Constitution First Amendment Act 1951, inserting public order in Clause 2. Hence, the ground relied upon by the majority in the cases of Ramesh Thapar and Brij Bhushan is no longer available. The word reasonable was also inserted in Clause 2 by the same amendment. The result of this twofold amendment is that if censorship is imposed in the interests of public order, it cannot at once be held to be unconstitutional as fetter upon the freedom of circulation, but its reasonableness has to be determined with reference to the circumstances of its imposition. In this sense, the introduction of the word reasonable has not been an unmixed blessing, for censorship of the press in times of peace is something unimaginable either in England or in the United States in modern times. But under our Constitution, as the Supreme Court decision in Birendra versus State of Punjab suggests, even at the time of peace, censorship may be valid if it is subjected to reasonable safeguards, both from the substantive and procedural standpoints, but not otherwise. The provisions before the court were sections 2 and 3 of the Punjab Special Powers Press Act 1956, which were similar to that in Section 71C of the East Punjab Public Safety Act 1949, which had been impugned in Brij Bhushan's case, except that in the Act of the 1956, what was authorized was even more drastic than pre-censorship, with a total prohibition. The court held that Section 2, which provided for a right of representation against the order of the authority and limited the power to a specific period and as to publications of a specified class, was valid. But Section 3, which had no such safeguards, constituted an unreasonable restriction. It would therefore follow that a provision for pre-censorship for a limited period in emergent circumstances and subject to procedural safeguards, as for example, as in Section 144 of Criminal Procedure Code, is valid. If, however, it is left to the absolute discretion of the executive authority, it must be held to be unreasonable. The Supreme Court has similarly upheld the validity of law sanctioning pre-censorship of motion pictures to protect the interests safeguarded by Article 19(2), as for example, public order and morality. It should be noted that when a proclamation of emergency is made under Article 352, Article 19 itself remains suspended, Article 358, so that pre-censorship may be imposed without any restraint. Thus, immediately after the proclamation of emergency on the ground of internal disturbance in June 1975, a censorship order was issued June 26, 1975 under Rule 48(1) of the Rules made under the Defence and Internal Security of India Act 1971. It should be noted that on the defeat of Mrs. Gandhi at the election of 1977, the proclamation of internal emergency was revoked on 21st and the press censorship order was revoked on the 22nd of March 1977. Article 9 would also be applicable in cases where Article 31A to 31C are attracted. These exceptions to fundamental rights, which have been introduced by subsequent amendments, will be discussed at the end of this chapter. Article 20 guarantees protection in certain respects against conviction for offences by prohibiting retrospective criminal legislation commonly known as ex post facto legislation. Double jeopardy or punishment for the same offence more than once, compulsion to give self-incriminating evidence. A provision against ex post facto legislation is contained in clause 1 of Article 20 of our Constitution, which runs as follows. No person shall be convicted of any offence except for violation of a law in force at the time of the commission of the act charged as an offence, nor be subjected to a penalty greater than that which might have been inflicted under the law in force at the time of the commission of the offence. This is a limitation upon the law-making power of the legislatures in India. A law is said to be prospective when it affects acts done or omission made under the law comes into effect. The majority of law are prospective in their operation, but sometimes the legislature may give retrospective effect to a law. That is to say, to bring within the operation of the law not only future acts and omissions, but also acts or omissions committed even prior to the enactment of the law in question. Though ordinarily a legislature can enact prospective as well as retrospective laws, according to the present clause, a legislature shall not be competent to make a criminal law retrospective so as to provide that a person may be convicted for an act which was not an offence under the law in force at the time of commission of that act, or to subject an accused to a penalty greater than that which might have been inflicted under the law in force at the time of commission of the offence. In other words, when the legislature declares an act to be an offence or provides a penalty for an offence, it cannot make the law retrospective so as to prejudicially affect the person who have committed such acts prior to the enactment of that law. The prohibition against double jeopardy is contained in clause 2 of Article 20, which runs thus: no person shall be prosecuted and punished for the same offence more than once. The expression double jeopardy is used in the American law but not in our Constitution. Nevertheless, clause 2 of Article 20 in effect lays down a similar principle as has been laid down by the Supreme Court in Venkataramanan versus Union of India. Article 22 refers to the judicial punishment and gives immunity to a person from being prosecuted and punished for the same offence more than once. In other words, if a person has been prosecuted and punished in a previous proceeding of an offence, he cannot be prosecuted and punished for the same offence again in a subsequent proceeding. If any law provides for such double punishment, such law would be void. The article, however, does not give immunity from proceedings other than proceedings before a court of law or a judicial tribunal. Hence, a government servant who has been punished for an offence in a court of law may yet be subjected to departmental proceedings for the same offence, or conversely, the immunity from self-incrimination is conferred by clause 3 of Article 20, which says no person accused of any offence shall be compelled to be a witness against himself. The scope of this immunity has prima facie been widened by our Supreme Court by interpreting the word witness to comprise both oral and documentary evidence, so that no person can be compelled to furnish any kind of evidence which is reasonably likely to support a prosecution against him. Such evidence must however be in the nature of a communication, the prohibition of is not attracted where any object or document is searched and seized from the possession of the accused. For the same reason, the clause does not bar the medical examination of the accused or the obtaining of thumb impression or specimen signature from him. Secondly, the immunity does not extend to civil proceedings or other than criminal proceeding. It has also been explained by the Supreme Court that in order to claim the immunity from being compelled to make a self-incriminating statement, it must appear that a formal accusation has been made against the person at the time when he is asked to make the incriminating evidence statement. He cannot claim the immunity at the some general inquiry or investigation on the ground that his statement may at some later stage lead to an accusation. Freedom of person or personal liberty is sought to be ensured by our Constitution by means of twofold guarantee, namely by providing that no person can be deprived of his liberty except according to law, Article 21, by laying down certain specific safeguards against arbitrary arrest or detention, Article 22. Article 21 of our Constitution provides that no person shall be deprived of his life or personal liberty except according to the procedure established by law. This article reminds us of one of the famous clauses of the Magna Carta: no man shall be given or imprisoned, diseased, or outlawed, or exiled, or in any way destroyed, save by the law of the land. It means that no member of the executive shall be entitled to interfere with the liberty of a citizen unless he can support his action by some provision of law. In short, no man can be subjected to any physical coercion that does not admit of legal justification. When therefore the state or any of its agents deprives an individual of his personal liberty, such action can be justified only if there is law to support such action and the procedures prescribed by such law have been strictly and scrupulously observed. Again, as under the English Constitution, personal freedom is secured by the Indian Constitution by the judicial writ of habeas corpus. See under habeas corpus Article 32 and 226, by means of which an arrested person may have himself brought before the court and have the ground of his imprisonment examined. And again, his freedom, if the court finds that there is no legal justification for his imprisonment, the court will also set the prisoner free where there is a law authorizing the deprivation of liberty of a person. But there has been no strict compliance with the conditions imposed by the law. The Supreme Court has more than once observed that those who feel called upon to deprive other persons of their personal liberty in the discharge of what they conceive to be their duty must strictly and scrupulously observe the forms and rules of the law. But in no country can there be any absolute freedom of the individual. The principle underlying the English Constitution is that it is the people's representatives assembled in Parliament which shall determine how far the rights of the individuals should go and how far they should be curtailed in the collective interests or for the security of the state itself, according to exigencies of the time. This was the theory adopted by the Constitution of India in saying that life and personal liberty are subject to the procedure established by law. The Supreme Court has, however, infused judicial review by holding that procedure inherently meant a fair procedure, so that Article 21 has been turned into a safeguard against arbitrary legislation. The history of this change in view is as follows. Until the 1978 decision in Menka's case, the view which prevailed in our Supreme Court was that there was no guarantee in our Constitution against arbitrary legislation encroaching upon personal liberty. Hence, if a competent legislature makes a law providing that a person may be deprived of his liberty in certain circumstances and in a certain manner, the validity of law could not be challenged in the court of law on the ground that law is unreasonable, unfair, or unjust. Under the due process clause of the American Constitution, 15th, 5th, and 14th Amendment, the court has assumed the power of declaring unconstitutional any law which deprives a person of his liberty otherwise than in accordance with the court's notion of due process, that otherwise than in accordance with the court's notion of due process, that is reasonable and fairness. In England, this is not possible inasmuch as courts have no power to invalidate a law made by Parliament. In the result, personal liberty is in England a liberty confined and controlled by law. It exists only so far as it is not taken away or limited by laws made by the representatives of the people. In Gopalan versus State of Madras, the majority of our Supreme Court propounded the view that by adopting the expression procedure established by law, Article 21 of our Constitution had embodied in English concept of personal liberty in preference to that of American due process, even though according to the minority, the result of such interpretation was to throw the most important fundamental right to life and personal liberty at the mercy of legislative majorities. The result, according to the majority, is due to the difference in the basic approach, namely that although our Constitution has imposed some limitations on the legislative authorities, yet subject to and outside such limitation, our Constitution has left our Parliament and the state legislatures supreme in their respective fields. In the main, our Constitution has preferred the supremacy of the legislature to that of the judiciary. It was also held that there is no safeguard for personal liberty under our Constitution besides Article 21, such as natural law or common law. In the result, when personal liberty is taken away by a competent legislation, the person affected can have no remedy. It is a striking feature of the development of constitutional law of India that after a long struggle, which may be said to have started tangibly since 1971, the minority view in Gopalan's case has come to triumph in 7-judge decision in Menka's case, which we have already noted. This case has categorically laid down the following propositions, overturning the majority in Gopalan. Article 19 and 21 are not watertight compartment. On the other hand, the expression of personal liberty in Article 21 is of the widest amplitude, covering a variety of rights in which some have been included in Article 19 and given additional protection. Hence, there may be some overlapping between Article 19 and 21. In the result, a law coming under Article 21 must also satisfy the requirements of Article 19. In other words, a law made by the state which seeks to deprive a person of his personal liberty must prescribe a procedure for such deprivation which must not be arbitrary, unfair, and unreasonable. Once the test of reasonableness is imported to determine the validity of law depriving a person of his liberty, it follows that such law shall be invalid if it violates the principle of natural justice. As for example, if it provides for the impounding of a passport without giving a person affected an opportunity to be heard or to make a representation against the order proposed. From Gopalan to Menka, thus the judicial exploration has completed its trek from the north to south pole. The decision in Menka's case is being followed by the Supreme Court in subsequent cases. Apart from the foregoing judicial salvage, let us now advert to the safeguards which the Constitution itself has provided in Article 22 against arbitrary arrest and detention. Hence, in a case coming under Article 22, the requirements of both Article 21 and 22 must be complied with. The procedural safeguards against arbitrary arrest and detention provided for in Clause 1 and 2 of Article 22 are: no person who is arrested shall be detained in custody without being informed as soon as may be of the grounds for such arrest. No such person shall be denied the right to consult and to be defended by a legal practitioner of his choice. Every person who is arrested and detained in custody shall be produced before the nearest magistrate within a period of 24 hours of arrest, excluding the time necessary for the journey from the place of the arrest to the court of the magistrate, and no such person shall be detained in custody beyond the said period without the authority of a magistrate. The above safeguards are not, however, available to an enemy alien, a person arrested or detained under the law providing for preventive detention. The Constitution itself authorizes legislature to make law providing for preventive detention for reasons connected with the security of a state, the maintenance of public order, or the maintenance of supplies and services essential to the community, or for reasons connected with defense, foreign affairs, or the security of India. So it would be competent to the legislature to enact that a person should be detained or imprisoned without trial for any of the above reason, and against such laws the individual shall have no right of personal liberty. The Constitution, however, imposes certain safeguards against abuse of the above power. Article 22, Clause 4 to 7. It is these safeguards which constitute fundamental rights against arbitrary detention, and it is because of these safeguards that preventive detention has found a place in the Part 2 of Fundamental Rights in our Constitution. The relevant provisions of Article 22 read as follows: when a person has been arrested under the law of preventive detention, the government is entitled to detain such person in custody only for 3 months. If it seeks to detain the arrested person for more than 3 months, it must obtain a report from a advisory board who will examine the papers submitted by the government and by the accused as to whether the detention is justified. The person so detained shall, as soon as may be informed of the ground of his detention, accepting facts which the detaining authority considers to be against the public interest to disclose. The person detained must have the earliest opportunity of making a representation against the order of detention. A law which violates any of the conditions imposed by Article 22, as stated above, is liable to be declared invalid, and an order of detention which violates any of these conditions will similarly be invalidated by the court, and the detainee shall forthwith be set free. Parliament has the power to prescribe by law the maximum period for which a person may be detained under the law of preventive detention. Preventive detention means detention of a person without trial. It is so called in order to distinguish it from punitive detention. The object of punitive detention is to punish a person for what he has done, and after he is tried in the courts for the illegal act committed by him. The object of preventive detention, on the other hand, is to prevent him from doing something, and the detention in this case takes place on the apprehension that he is going to do something wrong which comes within any of the grounds specified by the Constitution. These acts prejudicial to the security of the state, public order, maintenance of supplies and services essential to the community, defense, foreign affairs, or security of India. In fact, preventive detention is resorted to in such circumstances that the evidence in possession of the authority is not sufficient to make a charge or to secure the conviction of the detainee by legal proofs, but many still be sufficient to justify his detention on the suspicion that he would commit a wrongful act unless he is detained. Preventive detention is something unknown in the United States of America or the United Kingdom in times of peace. The adoption in India on a permanent footing of the power of the executive to arrest persons on suspicion, which is tolerated in other countries only in emergencies, cannot on principle be justified by any lover of liberty, but no proper assessment of this provision of our constitution is possible without taking note of the following circumstances. Firstly, detention without trial was not a new idea introduced by the makers of our constitution. For the first time, it was in existence since the early days of British India. Under the notorious Bengal Regulation, 3rd of 1818, the Bengal State Prisoners Regulation, and similar enactments in Madras and Bombay, which laid no fetters upon the powers of the government to detain a person on suspicion. Then came Rule 26 of the rules framed under the Defence of India Act 1939, which authorized the government to detain a person whenever it was satisfied with respect to that particular person that such detention was necessary to prevent him from acting in any manner prejudicial to the defense and safety of the country and the like. This was, of course, a wartime measure modeled on similar legislation in England during World War II, the validity of which had been upheld by the House of Lords. But even after the cessation of the war, preventive detention was continued in India as an instrument to suppress apprehended breach of public order, public safety, and the like by the Provincial Maintenance of Public Order Acts, under which there was a spate of litigation. The framers of our Constitution simply made it possible for such legislation to be continued under the Constitution, subject to certain safeguards laid down therein, because they painfully visualized that the circumstances which had necessitated such abnormal legislation in the past had not disappeared at the birth of India's independence. It is common knowledge that the Republic had its birth amidst anti-social and subversive forces and the ravages of communal madness involving colossal loss of lives and property. In order to save the infant republic from the inroads of any such subversive elements, therefore this power had to be conferred upon the state. But the framers of the Constitution improved upon the existing law by subjecting the power of preventive detention to certain constitutional safeguards, upon the violation of which the individual could have a right to approach the Supreme Court or the High Courts, because the safeguards are fundamental rights for the enforcement of which the constitutional remedies would lie. There have been a number of cases in which the courts have nullified orders of the preventive detention in proceedings for habeas corpus. Secondly, the above provisions of the Constitution are not self-executory, but require a law to be made by the legislature conforming to the condition laid down in the article, and preventive detention can subsist only so long as a legislature permits. The Preventive Detention Act 1950 was thus passed by the Indian Parliament, which constituted the law of preventive detention in India. It was a temporary act originally passed for only 1 year. Several times since Then the terms of the act was extended until it expired at the end of 1969. The revival of anarchist forces obliged Parliament to enact a new act named the Maintenance of Internal Security Act, popularly known as MISA, in 1971, having provisions broadly similar to those of the Preventive Detention Act of 1950. In 1974, Parliament passed the Conservative of Foreign Exchange and Prevention of Smuggling Act 1974, commonly referred to as COFEPOSA, as an economic adjunct of the MISA. While the MISA was in general aimed at subversive activities, the COFEPOSA is aimed at anti-social activities like smuggling, racketing in foreign exchange, and the like. MISA was repealed in 1978, but COFEPOSA still remains. Further power of preventive detention has been conferred on the central and state governments to safeguard defense and security of the country and to maintain public order and essential supplies and services by enacting the National Security Act 1980 and the Prevention of Black Marketing and Maintenance of Supplies of Essential Commodities Act 1980. With the increase in terrorist activities, the government had to pass in 1985 the Terrorist and Disruptive Activities Act 1985, commonly known as TADA. This has widely been used to curb terrorism. It may be mentioned that the number of detainees during the emergency of 1975-76 had soared up to 175,000. On the eve of coming to power, the Janata Party promised to abolish detention without trial. After coming to power, the Janata government came to realize the reality of the problem. Eventually, in April 1978, the MISA was repealed by Parliament, but the government refused to repeal the COFEPOSA because while the former related to political detention, the latter was aimed at social offences which required extra power to check when inflation, black marketing, smuggling, and like were rampant. The provision in clause 2 to 7 of Article 22 could not be altogether omitted. So long as preventive detention was authorized, COFEPOSA, the Janata government therefore sought to alleviate the rigors of the procedure for preventive detention by effecting changes in clause 4 and 7 by enacting the Constitution 44th Amendment Act 1978. But the relevant provisions of this Amendment Act could not be brought into effect immediately since some changes in the machinery of the advisory boards had to be made. Hence, the Amendment Act of 1978 empowered the central government to bring into force these provisions by issuing notifications. Paradoxically, however, before any such notification could be issued, the Janata government had its fall and Mrs. Gandhi returned to power in January 1980. The government has not issued any such notification notwithstanding adverse comments by the Supreme Court in view of the inordinate delay in the result. The original clauses relating to the preventive detention in Article 22 subsist still today, and the relevant provisions of the Amendment Act of 1978 solemnly passed by the Parliament remain a dead letter. Some states, as for example Jammu and Kashmir and Madhya Pradesh, have enacted state laws authorizing preventive detention which recall the old Preventive Detention Act of 1950. It should be pointed out in this context that the legislative power to enact law of preventive detention is divided by the Constitution between the Union and the states. The Union has exclusive power only when such law is required for regions connected with defense, foreign affairs, or security of India. A state has power concurrently with the Union to provide the preventive detention for regions connected with security of the state, maintenance of public order, or the maintenance of supplies and services essential to the community. A state has therefore a say in the matter of abolishing preventive detention detention on these grounds because it is the responsibility of the state to maintain public order. Entry 1 of list 2. Production, supply and distribution of goods so long as the concurrent power of the states to legislate for preventive detention with respect to the aforesaid grounds remains, and any of them feels the need for retaining or making state laws for preventive detention. It is practically difficult for the union government to impose its will on such states. Till then, the existence of Article 22 on the Constitution will be beneficial rather than prejudicial to the abuse of liberty, because the validity of such state laws can be challenged on the ground of contravention of the safeguards laid down in Article 22. In these circumstances, Article 22 continues to be the Constitution as the necessary evil, as an adjunct to the guarantee of personal liberty and the prohibition against discrimination. Our Constitution lays down certain provisions to prevent exploitation of the weaker section of the society by unscrupulous individuals or even by the state. Article 23 says traffic in human beings and beggar and other similar forms of forced labor are prohibited, and any contravention of this provision shall be an offense punishable in accordance with law. Nothing in this article shall prevent the state from imposing compulsory service for public purposes, and in imposing such service the state shall not make any discrimination on grounds only of religion, race, caste or class or any of them. Slavery in its ancient form may not so much be a problem in every state today, but its newer forms, which are labeled in the Indian Constitution under the general term exploitation, are no less a serious challenge to human freedom and civilization. It is in this view that our Constitution, instead of using the word slavery, uses the more comprehensive expression traffic in human beings, which includes a prohibition not only of slavery but also of traffic in women or children or the crippled for immoral or other purposes. Our Constitution also prohibits forced labor of any form which is similar to beggar, an indigenous system under which landlords sometimes used to compel their tenants to render free service. What is prohibited by the clause is therefore the act of compelling a person to render gratuitous service where he was lawfully entitled either not to work or to receive remuneration for it. The clause therefore does not prohibit forced labor as punishment for a criminal offense, nor would it prevent the state from imposing compulsory recruitment or conscription for public purposes such as military or even social service. Article 23 has an element of force. Special provision for the protection of children is made in Article 24, which says no child below the age of 14 years shall be employed to work in any factory or mine or engaged in any other hazardous employment. It is to be noted that prohibition imposed by this article is absolute and does not admit of any exception for the employment of a child in a factory or mine or in any other hazardous employment. As for example, in a railway or a port, Supreme Court directed that children should not be employed in hazardous jobs in factories, and positive steps should be taken for the welfare of such children as well as improving the quality of their life. And the employers of the children below 14 years must comply with the provisions of Child Labor Prohibition and Regulation Act, providing for compensation employment of their parents, guardians and their education. India under the constitution is a secular state, that is, a state which observes an attitude of neutrality and impartiality towards all religions. A secular state is founded on the idea that the state is concerned with the relation between man and not with the relation between man and God, which is the matter for individual conscience. The attitude of impartiality towards all religions is secured by the Constitution by several provisions, Article 25 to 28. Firstly, there shall be no state religion in India. The state will neither establish a religion of its own nor confer any special patronage upon any particular religion. It follows from this that the state will not compel any citizen to pay any taxes for the promotion or maintenance of any particular religion or religious institution. No religious instruction shall be provided in any educational institution wholly provided by state funds. Even though religious instruction be imparted in educational institution recognized by or receiving aid from the state, no person attending such institutions shall be compelled to receive the religious instruction without the consent of himself or of his guardian, in case the pupil be minor. In short, while regular instruction is totally banned in state-owned educational institutions, in other denominational institutions it is not totally prohibited, but it must not be imposed upon people of other religions without their consent. Secondly, every person is guaranteed the freedom of conscience and the freedom to profess, practice, and propagate his own religion, subject only to restrictions imposed by the states in the interests of public order, morality, and health, so that the freedom of religion may not be abused to commit crimes or antisocial acts, as for example, to commit the practice of infanticide and the like. To regulations or restrictions made by the state relating to any economic, financial, political, or other secular activities which may be associated with religious practice but do not really appertain to the freedom of conscience. To measures for social reform and for throwing open of Hindu religious institutions of a public character to all classes and sections of Hindus. Subject to the above limitations, a person in India shall have the right not only to entertain any religious belief but also to practice the observances dictated by such belief and to preach his views to others. Thirdly, not only is there the freedom of the individual to profess, practice, and propagate his religion, there is also the right guaranteed to every religious groups or denominations to establish and maintain institutions for religious and charitable purposes, to manage its own affairs in matters of religion, to own and acquire movable and immovable property, and to administer such property in accordance with law. To those who have any idea as to what part religion plays in the entire being of the common man in India, the bold pronouncement in the above article must appear to be astoundingly progressive, or more so if we consider that while the other half of the truncated territory consisting of a large mass of Hindu minority has adopted Islam as the state religion in her constitution, India stands firm regardless of her environments. It is to be noted that this guarantee is available not only to the citizens of India but to all persons, including aliens. The ambit of the freedom of religion guaranteed by Article 25 to 26 has been widened by the judicial interpretation that what is guaranteed by the Article 26 and 25 and 26 is the right of the individual to practice and propagate not only matters of faith or belief, but also all those rituals and observances which are regarded as integral parts of the religion by followers of its doctrines. Of course, religion is a matter of faith, but it is not necessarily theistic, and there are well-known religions in India like Buddhism and Jainism which do not believe in God. On the other hand, though a religion undoubtedly has its basis in the system of beliefs or doctrines which are regarded by those who profess that religion as conducive to their spiritual well-being, it would not be correct to say that religion is nothing else but a doctrine of belief. Similarly, each religion, denominations or organization enjoys complete autonomy in the matter of deciding as to what rites and ceremonies are essential according to the tenets of religion they hold. Regulation by the state again cannot interfere with things which are essentially religious, but the court has the right to determine whether a particular rite or observance is regarded as essential by the tenets of a particular religion, and to interfere if a particular practice offends against public health or morality, or not being an essentially religious practice contravenes any law of social, economic and political regulation. It should be pointed out in this context that the word secular is a dubious word capable of diverse meanings, and one of its dictionary meaning is concerned with the affairs of the world as opposed to religious affairs. This has not only caused confusion amongst teachers of political science and law in India, but has also been taken advantage of by interested parties. This state of confusion has been set at rest by authoritative pronouncement made by the Supreme Court in a 9-judge decision as follows. Secularism in India does not mean that the state should be hostile to religion, but that it should be neutral as between the different religions. Every individual has the freedom to profess and practice his own religion, and it cannot be contended that if a person is a devout Hindu or a devout Muslim, he ceases to be secular. The use of the vague word secular in the preamble would not be override the enacted provisions in Article 20 to 30 or Article 351, so that the preference of Sanskrit in the academic syllabus as an elective subject while not considering this status to Arabic or Persian or the like would not militate against the basic tenets of secularism. The neutrality of the state would be violated if religion is used for political purposes and advocated by the political parties for their political ends. An appeal to the electorate on ground of religion offends secular democracy. Politics and religion cannot be mixed. If a state government does this, it will be a fit case for application of 356 and of the Constitution against it. It is in this sense that secularism is to be regarded as a basic feature of the Constitution. It is amazing that some Christian leaders assert that the word propagate in Article 25(1) gives them a fundamental right to convert people of other faiths into Christianity by any means. This assertion, followed by agitation, is particularly amazing because it seeks to undermine the decision of the Supreme Court in Stanislaus case in January 1977, which had been brought by a Christian father who sought to invalidate a Madhya Pradesh Act because it made it a penal offense to convert or to attempt to convert a person by means of force, fraud or allurement. Odisha had earlier passed a similar act which used the word inducement constitutionality that act had been challenged by several members of the Christian community, including a Christian society, a professor of geology, and several priests. Both the acts were taken up together by the Supreme Court, and the contentions of the Christian community were rejected in toto by Supreme Court, laying down the following propositions of law which are under the Constitution binding upon all courts in India. The right to propagate in Article 25(1) gives to each member of the early religion and right to spread or disseminate the tenets of his religion, say by advocacy or preaching, but it would not include the right to convert another, because each man has the same freedom of conscience guaranteed by that very provision on which the Christian relied. The equal freedom of conscience belonging to each man under Article 25(1) means that he has the freedom to choose and hold any faith of his choice, and not to be converted into another religion by means of force, fraud, inducement, or allurement. He can, of course, voluntarily adopt another religion, but force, fraud, inducement, and allurement takes away the free consent from the would-be convert. Even assuming that a particular religion had the right to propagate its tenets by any means, including conversion, the state has the right and duty to intervene if such activity of conversion offended against public order, morality, or health. Because the guarantee of freedom of religion in Article 25(1) is subject to limitation of public order, morality, or health as follows. 25(1) subject to public order, morality, and health, and to the other provisions of this part, all persons are equally entitled to freedom of conscience and the right freely to profess, practice, and propagate religion. If any such right to convert be considered, such right would belong to every citizen, so that there would be inevitably a breach of public peace if every religion community carried on to campaign to convert people belonging to other faiths. By the use of force, fraud, inducement, or allurement, the state was therefore constitutionally authorized, nay, enjoined to maintain public order by prohibiting and penalizing conversion, including attempt to convert. If force, fraud, inducement, or allurement was used by the person or person advocating conversion in any particular case, this is exactly what had been done by the MP and Orissa Acts. The Supreme Court therefore upheld the constitutional validity of both the MP and Orissa Act after rejecting every plea raised on behalf of the Christian parties. After this pronouncement of the Supreme Court, the Arunachal Pradesh legislature passed a bill modeled exactly on the MP and Orissa Act, which had been held to be valid by the Supreme Court, and submitted it to the President for its assent. A private member of Parliament, Sri O.P. Tyagi, presented before the Lok Sabha a similar bill, which, if passed by Parliament, would be applicable to all states of India. The Christian community at once started agitation and demonstration against these two bills, with threats against severer resistance if these measures were passed. They politicized the issue with the slogan that it was a campaign against Christian religion. In particular, this contention involves suppression of truth on the following points. Neither of the disputed bills was labeled against the Christian religion as such, but would have operated against any religious community, including the Hindu, Muslim, Sikh, etc., which resorted to any of these unlawful means, force, fraud, inducement, or allurement, in order to convert a member of another faith to its own fold. that all the legal points now raised against these two pending bills were taken by the Christian parties to the Madhya Pradesh and Odisha Acts case, but were definitely rejected by the Supreme Court. Those who rely on the international charters in support of their freedom to convert have not mentioned Article 18.2 of the International Covenants on Civil and Political Rights 1966, which says no one shall be subject to coercion which would impair his freedom to have or to adopt a religion or belief of his choice. This is all about today's fundamental rights and fundamental duties. Thanks, regards.